1, Criminal Appeal 138 of 2019.
The result this court does not find any reason to interfere with the order if it's able to 16 parts of the defeating the respondent number 2, the giving him, and the other prohibitions will be in the government. According to this system.
Deeply affects.
May I seek a lordship's indulgence?
Item 2, Criminal Appeal 283 of 2025, along with IA Criminals 807 of 25.
We have upheld the conviction. But insofar as the sentence is concerned, we have modified that from the 20 years. Others remain same. The IS also disputed. Yes, mentioning.
My lord, if I may be allowed to make a mention. Item 40, this is hearing item, my lord, criminal appeal.
Yes.
My lord, I have some personal difficulties because some hearings has been fixed before the Chief Justice today, my lord. So if this matter can come up any other time, my lord, after 2 weeks.
Have you informed the other side?
Yes, my lord.
His
Yeah,
charge shall be that. Please write down Miss Linda L. Humble, learned public prosecutor, appearing for the state of Mizoram, submits that she has some under this place for adjournment for 2 weeks. She also submits that she has taken the consent of the learned counsel for the other state. We have this matter again after 2 weeks on a date to be fixed by the host. Yes.
May I please, your lordship, is for listing of a I, your lordship, for withdrawal of the maintenance, area maintenance amount that was deposited by the petitioner in the registry, before the registry, your lordship, before vacation, your lordship.
Please, my lord. My lord, with due consent of the other side, my lord, I seek my lord's indulgence, my lord, in mentioning item number 10. An adjournment slip was circulated yesterday, my lord. I'm for the appellant. My lord, the other side is present, my lord.
Please write, an adjournment slip has been circulated by the learned counsel for the appellants. And the same is not objected to by the learned counsel for the other side. We have understand that we listed again as after this convocation.
Grateful.
Is a lordship, lordship, I beg to mention item number 15, lordship with set with an adjournment slip, lordship. Any date after vacation,
Also, when you fix a date, also.
any date after.
Matter is pending from 19 or something.
Similar order, okay? List the matter again on.
Lordship, lordship, another prayer, lordship, item number 16 to 18, your lordship.
Item number,
16 to 18,
right,
lordship. Adjournment, lordship.
yes. You want a date too?
Lordship, any date after vacation.
Give a date.
Lordship.
Similar order, no, just a date will be different, 37.
Another prayer, lordship, lordship, bring up for listing of a fresh admission matter, lordship, on Wednesday.
What is the urgency?
Lordship, I mean dismissed from service, your lordship. The single writ petition has been dismissed, your lordship.
Writ
That is-
appeal.
Lordship,
Appeal.
fresh matter, your lordship. 17-6, your lordship, motion day, your lordship. 17-6.
17 is what?
Wednesday.
Have it
Motion.
Wednesday, yes.
Lordship.
May I please, my lord?
Yes.
My lord, I beg to mention item number 29, lordship. Conducting council has some personal difficulties, lordship. I am preparing for the pass over the day only, lordship.
Who's the council?
Mr. S. Samaria, lordship.
Yes, Maria and council. You should not take that some person. Application. And prayer for adjournment has been made on behalf by Mr.
MM Zaman, lordship.
MM.
Zaman, lordship.
Someone. Okay, he might stand for adjourn for the day.
Lordship, next, any date, lordship, if possible.
You say that adjourn for the day?
Yes,
what?
lordship, day only, lordship, but lordship, it will come
It'll come after summer vacation. List again after summer vacation.
highly always.
I please, your lordship. Sir, I beg to mention item number 41. I have taken consent of the applicant, lordship. 41. May matter may kindly taken up after petition, lordship. We have taken consent of the applicant.
The prayer of Mr. They are, they will learned counsel for the state respondents and not opposed to my in this. Stands and joins. Just to get after the incidents.
May I please,
Okay.
Lordship? Lordship, I beg to mention item number 42. An affidavit has been filed day before yesterday. Kindly the record, my affidavit may be tagged with the record, your lordship.
Affidavit for what?
A vital information regarding the case, your lordship.
We post it next week then. Okay. That's your good name? Your name, please?
S. Hazarika.
Miss S. Hazarika, learned counsel for the appellate, submit that an affidavit incorporating certain vital information was filed yesterday. And submit that the matter may be called. Considering the submission, the registry shall verify and connect the affidavit said have been filed yesterday and list the matter on 16/6.
May it please your lordships, with the consent of the other side, I beg to mention item number 8, lordship. As per last order, we were asked by the honorable court to get some instructions. We have received the instructions. We would like to place it in the form of an affidavit, lordship. Kindly some time may be granted to
You're for the,
for respondent number 5, lordship.
Who is that?
High Court,
for the High Court.
Guwahati High Court,
Okay.
on behalf of Mr. H.K. Das,
Regarding interest,
lordship.
is there any interest?
Lordship, we've just received the
You
instructions.
don't know. Your good name, please?
D. Mohanto on behalf
Ms.
of
D. Mohanto, learned
Das.
counsel appearing for,
H.K. Das standing.
appearing on behalf of Mr. H.K. Das, learned standing counsel, Guwahati High Court, representing respondent number 5. Praise for how much time?
After vacation, lordship.
Praise for 2 weeks' time. To file an affidavit incorporating the instructions that they have received in terms of the last court's order. Stop. Have you informed the other side?
Yes, lordship. Mr. R.
The, was that the consent of the other side has also been taken. We have put up list again of this information. On so and so, give a date.
Maybe lordship, my lord.
Yes.
Much obliged, lordship.
My lord, I am extremely sorry, my lord. Item number 14, my lord. The respondent took time without consent to me. That enjoined the settlement, my lord. At least date may be fixed, my lord.
Which item?
On 4, my lord.
Which item?
On 4, my lord. 14. 1-4.
Not mentioned.
They adjourn,
40, not 14.
sorry, my lord, sorry, I am wrong information, sorry.
Item 3, promotion.
My lord, as per last order, my lord, they have been asked to produce the instruction regarding the 15 Finance Commission bills, how to pass, my lord. Related page 8, my lord, of the petition. There is para 7, my lord, it is, I have mentioned here that without mandatory authentication by accredited engineer and reportedly lack of essential measurement book details, such bills are passed, my lord.
Who is appearing for the other side?
Lordships, PNRD standing, PNRD is appearing in this matter.
Okay,
I'm appearing for respondent number 3.
for number 3. You are for number 3.
Yes, your lordship.
Who is supposed to respond in terms of the last court's order?
PNRD.
PNRD.
Lordship, awaiting instructions also.
You represent PNRD. How come you await instructions? Matter was of the order was passed in March. April, May, June, 3 months have gone.
Lordship, we are awaiting the instructions for more time.
Sorry,
We are awaiting the instructions for such a more time.
how long should we await?
2 weeks.
Weeks. Your good name, please.
Lordship,
Your name,
P. Thapa. On behalf of S. Datta.
P.
Thapa.
Miss P. Thapa. Learned counsel appearing on behalf of Mr.
S. Datta.
S. Datta, standing counsel,
PNRD.
PNRD. Submits that they are yet to receive instructions in the matter. In terms of the last court's order dated 18/3/2026. And she therefore prays for further 2 weeks time to receive complete instructions in the matter. Considering the same, stands adjourned. Will you sit again on Wednesday?
Obliged.
Obliged.
4 and 5.
May it please your lordship. Lordship, before your lordship starts with the matter, I had passed down a copy of a previous order in this matter, your lordship. Lordships may not like to take up this matter, your lordship. In item number 5, his lordship had appeared considerable amount of time.
Is this matter before any other plans? We have one of us within bracket brothers.
Lordship may, however, fix a date, your lordship. Lordship. Much.
Lordship, just for a moment, in item 4, actually, when this matter was heard at some length, the Honorable Chief Justice was pleased to tag it with item number 5, saying that a similar matter is pending. So, Lordship, I'm in a limbo actually, because notice was not issued, but it was written that tag with the other matter. Lordship, may I pray, my lord, at least notice be issued, at least I may be also in.
This difficulties there. Technical difficulties there.
Okay.
We would have definitely obliged you up there, but problem is that.
Okay, I understand.
This case, lordship. Affidavit, lordship, I filed yesterday, your lordship. It's not on record, your lordship. Yesterday I filed, your lordship.
So then come up with the affidavit.
Yes, lordship.
You have received copy,
I received copy, lordships, after a week, lordship.
Mr.
DJ Das, your lordship,
DJ
person number 127, your lordship.
Learned counsel appearing on respondent number 177. Respondent, he represents our file that found affidavit on 11/6/21. Stop. Mr. F2 board, we have learned counsel. Here's for the petition and submits that he has also received copies. However, the affidavit is not yet connected to the report. Therefore, it is official verified to connect the same to the report. This must be after a week.
Much obliged.
Please, your lordship. Well, the writ petition. Well, this is against an order passed by the tribunal. And when it was moved, my lord, then the honorable court passed an order requiring us to bring on record two consequential orders which the authorities have now passed in pursuance of the order passed by the tribunal. That we have brought on record by way of an additional affidavit, and we have also filed IA 1961 seeking incorporation of those facts into the writ petition. That is absolutely my lord in terms of the previous order passed by this honorable court. My lord, order. 22.5. Yes, ma'am. 22/5/2024. Your lordship may kindly see the last paragraph. Penultimate paragraph. My lord, petitioner in that case would be required to amend the pleadings and also bring the two orders on record by way of an affidavit. So that we have done. You've done by filing the IA. By filing IA. You want to incorporate in the amended petition. Yes, yes. In that case, if it's allowed, you have to amend and file a recast. Yes. So IA, your lordships. Correct. IA lordships may allow. And my lord, since there is also a prayer for interim stay of the tribunal's order in the main writ petition, that your lordship may consider.
That lordship, without incorporating, how could lordship, because
Just a minute, my lord, the things which we want to incorporate in the pleadings, additional pleadings, my lord, these are already stated by way of an additional affidavit. IA 1961 is also there, my lord, and there is also another additional affidavit filed on 8th of June. So in fact, my lord, both the, the facts are otherwise also available on the records of this brief. Minus the IA also, your lordship may consider the prayer.
but that termination order already issued, lordship.
No, I am not on the termination order. I am on the order of the tribunal.
What interim order is seeking?
Well, we are only seeking stay of the tribunal's order because the termination order which has been passed by the authorities, that is exactly based on the order passed by the tribunal. If your lordship will kindly see the page 164, which is by way of additional affidavit we have brought. 164, your lordship may kindly see paragraph 3. Paragraph 3 states 164 of this brief, my lord, it will be in the additional affidavit which we have filed on 8th of June. So 164 paragraph 3, your lordship will kindly see. Consequent upon the court verdict issued by the tribunal so the outstanding BOI, that is Board of Inquiry, has been conducted at this base by removing so working under you from service with effect from 14th May. In this regard, speaking order duly signed by the competent authority is annexed herewith for information to the individual concerned. Original speaking order in post. So practically, the order of termination is based on the order passed by the tribunal.
That is why, that is to be examined by this court.
Lordship?
That is to be examined by this court ultimately. So at this stage, where is the?
No, my lord, since on the writ petition, since already notice has been issued, my lord, your lordship may kindly consider the interim prayer. Because on that day, interim prayer was not considered because these facts were not before the court. That's why court permitted us to bring it by way of an additional activity.
First thing first, you get the thing incorporated, we'll consider that on the next day. Not today. Hard to spell. Yes. And then see the step by step. They are moving that. for the applicant to submit that this application is filed. Print certain facts and documents as was permitted by this court by order dated 22/5/2026 in the amended petition. He submits that incorporation of the same would be necessary in the amended petition for effective adjudication of the same. And therefore, the prayer of the applicant may be allowed. Miss
B Sharma.
B Sharma, Ladat CTC, preparing for the respondent, Union of India. Fairly submits that she has no objection in the IAS allowed to explain. The and allowed. It goes on. Then in the main, you write in view of the order passed today in IAC number 1961 of 2026. The petitioner will file a reclassification incorporating the amendment. Stop to be made. Same should be done within a period of. Same should be filed within a period of
1 week, Miller.
1 week. By furnishing a copy of the same to the Red Council of the prayer for interim. It's kept open to be considered
On the next day.
on the next day.
Miller, date may be fixed.
List again of
15/7 will be too late, Miller, because I am out of employment, Miller. If in this month, any day, Miller. If necessary, I'll try to complete the formalities by 3 days.
Going to 6.
22/6.
Yes.
Much over.
Orders, item 22.
Please, your lordship, paper book we have received, sir, fixed for hearing.
Conviction under
NDPS Act, my lord.
binding case. Parties are represented by the respective ground and they submit that because of the speech when it's them. That the matter will be reported. If you have number, please the matter hearing despite its own time.
Mr. Lordship. Mr. Lordship, I have got the paper book, my lord. The case is fixed, ready for hearing, my lord.
Similar. Order number 2 has been served.
Lordship, it is awaited.
Last time also it was awaited.
Lordship, my learned friend has said we have talked with the question, Lordship.
You want some more time?
Lordship.
The matter is listed today in order to find out about the status of the notice sent to respondent number 2. However, Ms. A. Begum, learned additional BP, appearing on behalf of Mr. Karan Kaushik,
Lordship.
submits that some more time is required to find out the status. Accordingly, this respect will be.
Lordship.
Five.
Prohibited time to supplement service.
Lordship 24, I'm appearing for the.
25.
24.
You're at 24.
I'm in 24.
The earlier case.
Earlier case, sir.
We have adjourned for 1 week.
Lordship, 2 weeks because next week I will not be here.
It's all right. Only thing is that we wanted to know about the notice to respond number 2.
Yes, that was the issue.
Even in your absence also, we can, there's no issue.
Okay.
Oh, you want, you want it that?
Today my presence will be shown. Of my absence.
You write one more line, Mr. So-and-so, learned, write this clearly, the applicant is present.
Hello, guys. Paper book is there, Lordship. Matter may be fixed for hearing. Paper book, I have not.
Conviction under,
302, Lordship.
okay. Then civil order at the early. For hearing as question. Oh. Sure.
I have not
You
received.
have received,
No, Lordship, I have not yet received.
okay, one more line, a copy of the paper book is handed over to the learned amicus curiae.
Legally it comes.
Today it's right, please write a name, okay. Your L Davy.
LD. Okay.
This to give us its own.
Please, your lordship. The lordship may not take up this matter.
Why?
At page 95, Honorable Justice Majumdar appears for the petitioner before the single court, lordship.
He's better for the other bench without one of us. Bracket.
Good night, lordship.
May I please, Your Lordship? Well, in this case, my lord, for the suspension of sentence, the appeal is already been admitted, my lord. Lordship, kindly take up my IA and 317 26 my lord. Paper book is also before your lordship. My lord, the
Fix the matter for hearing.
my lord, this is an absolutely case, my lord, for a bail, my lord. That is why, my lord, this is a case, my lord, and the victim who claimed to me my maid.
No, that's correct, but it may also be an absolute case for acquittal
My
also.
lord, that will take some time, my
Why
lord,
not?
because of the law, lordship knows that dependency and the hearing of the appeal is always very difficult. And the person is already in the custody for,
Since when?
since, my lord.
Were you on bail?
No, no, I am not on bail, my lord.
No, during trial.
Yes, yes, I am during trial, I am on bail, my lord. During trial, I am on bail. Date of judgment, my lord. Date of judgment, my lord. 22/9/25. Since then, I am in custody.
Around 7 months.
Last 7 months, I am in custody without being hearing, my lord, because of this. My lord, here, what happens, my lord?
But you are there for a reason. It's not.
No
that there's
reason
some
I'll show, my lord.
outside.
What is the perverse reason? Only two line, lordship. Only two things I'll show. Lordship is not satisfied. Lordship will definitely reject my will. The whole case is that she happens to be my maid, my lord, for 2 months. First month, there is nothing. And in the second month, the allegation is that I have continuously for 10 days, there is a forceful physical relation. Continuously for 10 days. On the 10th days, she fled away from my house, reported the incident. The doctor on that day verified there's nothing. No injury, nothing. No sign of rape. Even then, there is an allegation of 10 days of continuous harassment, my lord, physical relation, forceful. That is our allegation in the 161 statement. That is in 161 statement. Sorry, my lord, that is for the first time in the court. That the harassment for the continuous 10 months, that's also for the first time in the court. That is admitted by the trial court. But the trial court rejected. We have proved the contradiction also. that this allegation is for the first time, it is not before the IO. That allegation has been proved. Court also accepted that allegation, and the view of the court is that because she belongs to a rustic family, my lord, a rustic woman, that there may be some discrepancy. How could be, my lord, that major contradiction that she was continuously for 10 days, she was subjected to physical relationship. That was for the first time in the court, not in the 161. And that is admitted by the court. Even then, court has, in the judgment, Lordship, kindly turn to now. Page 83 of the paper book, my lord.
Is the FIR?
No, my lord. This is the contradiction of
Paper book.
paper book, my lord. Page 83 onwards. Now, in the 83, my lord, firstly, the Lordship kindly, the Roman 1, firstly, according to the defense counsel, the victim was not consistent on the date of incident and the sexual assault, and also made the varied statement before the different authorities. When the victim was under the cross-examination, it was suggested to her that the none of the previous statement, she stated accused has physical relationship with her for 10 continuously, but one day she took height on the terrace of the accused house and stayed there all night, and it then proceeded to the police station with the help of a vegetable vendor in the neighborhood and all.
Miss C. Chaudhary. For the applicant. Who submits that by filing this application under section 430 the PNSS, the applicant pays for suspension of the execution of the sentence. And the judgment and order passed by the learned special judge POCSO Kamrut, bracket N. In sessions, bracket special case number 17 of 2020, by which the applicant has been convicted under section 376, bracket 2, APC, and sentenced to undergo rigorous imprisonment for 20 years and to pay a fine of rupees 5 lakhs to the default court. Of the learned senior counsel submits that from the evidence of the prosecutors, it can be seen that whatever she had stated in her examination of chief had been taken during the cross-examination, as she was not able to recollect what was written in the FIR. He or further submits that what was narrated in her examination of chief is also not to be connected, is also not to be found in her statements made before the police under section 161 CRPC. So, the
was for the first time during the trial that she had made such a statement. Stop under the circumstance. There is doubt on the veracity of our claim made the FIR against the applicant. Stop. Not only this, the medical evidence also does not go to support the projected case of the applicant or the victim that they have been continuously subject to rape for 10 days. In absence of such injury, as per the medical evidence, it is clear that prosecution has failed to move the case beyond reasonable. In the applicant clearly is entitled to be given. Now, he submits that the applicant otherwise is also a doctor of repute. He has spent more than 7 months in custody after his conviction. He further submits that he was on bail during the trial. Not considering the same, the learned senior counsel submits that pending carrying consideration of the appeal. The appeal sentence imposed upon her may be suspended and the applicant released. Next paragraph contract. This gave a learned additional exam. Submits that the applicant, the victim in her examination in chief had clearly proposed that it was the applicant who had committed rape. And that there might be some discrepancies in our statements, which otherwise does not go to the root of the matter. Stuff as it is, the learned, the victim has not attended school and she being an illiterate girl. The same also has to be taken into account. She also submits that the evidence of the PW number 4 also goes to show that the applicant has also encountered similar problems while functioning as a doctor, the hospital concerned. Since it is a settled position in law that the statements of the prosecutrix alone is sufficient to convict the accused for offense of rape. Same is to be on the way through to the application of the applicant may not be allowed at this stage. And instead the entire appeal may be allowed expeditiously. Submissions of the rival parties, submissions of the counsels of the rival parties have been exhibited.
Stop. This, as already stated, this is an application seeking suspension of the sentence. And prima facie from the evidence led by the prosecution, including that of the prosecutors and that of the medical officer and the medical examination itself. I roughly feel that while it is the burden of the prosecution to prove their case beyond reasonable doubt. But the materials available on court prima facie both show that there is a possibility of the applicant of the applicant being given the benefit of doubt. So under the circumstances, to keep him incarcerated in a considered room. Be justified. Further, it is also seen that the applicant was on bail during trial. There is no material available on court to show that the same has been, bail conditions have been violated. Stop. Another aspect of the matter is that considering his antecedents and his background, cannot be said that there are chances of him absconding. It released on bail. Stop. Next item. Therefore, one consideration be trying to allow the application. That's very good. Accordingly, the hearing post upon the is hereby suspended and shall be released on bail on furnishing a bail bond of rupees 20,000 with one local surety of the letter to the satisfaction of the trial judge.
Obliged, madam. Obliged, madam. Oh, madam. Already been admitted, my lord. Paperwork is ready.
What about the history service? Party service.
Hearing.
Here, obliged.
So it's on third. Keep you.
May I please your lordship?
Yes.
May I please your lordship? Lordship, I am appearing on behalf of OS Mannat. Lordship, as per last order, we were directed to take fresh step upon respondent number 5. But due to somehow we could not take a step. Allow us 1 week time, lordship.
Good night, please.
M. Begum.
prayer of Mr. Bega. Further 1 week time is granted to take fresh steps upon this matter. By speed. In terms of the order dated 27/3/2026. List again after the sum of it.
May I please, Lordship? Appeal is already admitted and LCR has received, Lordship. Lordship may direct to prepare the paperwork, Lordship.
What about notice?
Lordship,
Respond number 2.
Madam Chair, office note, I have not seen any note regarding steps. Office has also not received. Note. Madam? Yes. Yes.
But I'm supposed to.
Madam, they will take steps through registry. They will take steps through registry. Registry will send it to our office, then our office will send it to police station. And there are sometimes, my lord,
You have not taken steps?
Lordship,
Have you taken or not?
we have taken the steps,
When?
Lordship.
It is not indicated in the order sheet. Office note also.
sometimes there is a direction also to give soft copy directly to our office, but in that case, I have not seen any direction.
There is no direction.
I have to check.
So what? You take steps that.
Lordship,
Guarded legal aid counsel from the appellant shall take steps. The service of notice upon respondent number. In the manner prescribed. Which should be routed to the office of the guarded legal secretary. Claim should be done within 3 working days. Then paper. Since TCR has been received, this shall start preparation of the paper. List again after some of it.
If I may seek your lordship's indulgence, my lords.
Yes.
Item 29 of today's list, my lord, I was not informed that time would be taken. I appear for the respondent, the sole respondent in the instant case. If a date may be fixed, I am given to understand that the matter will be taken up after the holidays. If a date may please be fixed after the holidays.
All right, we'll have a date.
Deeply obliged, lordships. After the holidays.
Yes. You will form item 29 and 27.
Deeply obliged.
Yes. Nice for it. Any matters? Others are still there. Others. Easy escalate, isn't it? So 31 onwards, we'll have. We'll come back. We'll come back.
It's for consideration of the bill and convicted for 20 years in a or aggravated penetrative sexual assault in a POCSO case. And I'm told that the informant has been served the notice.
Notice, sir.
Today, if your lordship,
Yesterday on the It has been served.
And from March, this appeal is pending. It's for consideration of my bill.
Let somebody be appointed. We consider.
I'll serve the copy during the course of the day today. Am I customary, Your Lordship? May kindly take up the matter on Monday next, madam. I'll serve it during the course of the day. Your Lordship will appoint an amicus curiae.
Objection also filed.
Objection has already been filed. We have all gone through it. But this is absolutely a misuse of the POCSO Act. The witness has admitted that she has been tutored, and as per the instruction of her parents, she has deposed. There is a land dispute. After this POCSO case, they have grabbed the land of the
case. Mr. R. Kaushik learned additional PP by producing copy of the acknowledgement slip by the opposite judge of Palash Pari Police Station, which that notice has been served to the informant, bracket respondent number. Since no one appears, then you write like this, accordingly, notice upon the respondent number 2 is accepted to be complete. Since no one appears for respondent number 2, we deem it appropriate to appoint.
There are number of amicus curiae even present in the court today. Anyone will do. But serial number 20 is also present in the court. I can see her.
Okay, we're going serially as per the list.
Yes.
We appoint Shri Arangshu Thar.
Hello?
Arunangshu Thar as the
Yes.
amicus curiae.
Yes. Yes.
Who represent
know
respondent number.
To serve the copy during the course.
Applicant took appellant to serve a copy of
The memo of appeal along with the I,
memo of appeal along with the IA,
including the objection filed by the state also.
and also the objection filed by the state. To Mr. So. ECR there? Yes. ECR has been received. Office shall prepare the paper book for the cost of the appellant.
I have given for consideration of my bill for all the documents which I will refer. Entire paper book only I have made it on myself. In the memo of appeal, I have enclosed all the deposition, the evidence of the
Correct, but we also direct the normal paper book to West.
But for IA pilot, I think the memo is sufficient.
We'll have it on Wednesday.
But may I pray that on
17th.
22nd, Monday?
22nd.
Yes, I'll be out of station from
All right.
16th.
Place the IA for consideration on 22nd, June 2026 as paid.
We are deeply obliged.
Yes.
As per last order, I have to pay rupees deposit 30,000 to before the registry of this honorable court. Accordingly, Lordship, I informed the matter to the petitioner, but he has not paid the amount till date. Read it to the petitioner, to your lordship.
This is a condition. We dismiss it then.
Then we have, your lordship, yes, one chance may be given because I have indicated that things to the petitioner.
Mr. M. Khan, learned counsel for the petitioner, raised for and is granted. Further,
We have 1 month time, lordship, immediately after vacation.
is given one more chance to ensure the compliance of the court's order dated 25/2026. Please be matter again on source. That appears for the petitioner of the matters called. This note dated 9/6/2026 indicates that on tracking the postal consignment, notice appears to have been delivered to respondent number 1. However, as no one appears for the petitioner as well as respondent number 1. The matter be listed again.
Happy. In this case, we were required to take steps, but unfortunately, we did not take steps. What may kindly
Steps on,
respond number 1.
Madam, you are court.
Respondent number 2 to 5.
Any submission? As paid for by the learned counsel for the applicant. For the 3 days time?
Yes.
3 working days time is granted. Taking steps for service of notice on respondent number 1 by speed post. As well as by usual process. List again after 2 weeks.
Much.
55.
My lord, as per office note that 10/6/26 steps on respondent number 7 has not been taken. We may kindly be allowed some more time to take the steps.
As paid for by Miss, your good name? Your name?
Puri.
G.
Puri.
Puri. Learned counsel for the applicant. Other three working days time is granted. Both taking steps. Service of notice upon respondent number 7 by speed post. Just again after 2 weeks.
The matter may be possible for the time being. D. Sharma is appearing. She is in another court, lordship.
Who's appearing for the other side?
My lord, I am hearing for the respondent.
Yes, any objection?
My lord, yes, I have objection, my lord.
Then where is your objection?
My lord, I have filed.
Oh, you have filed.
Yes.
Where is the counsel for the applicant?
Lordship, she is on decks in another court, Lordship.
She. B. B. Sharma.
B. Sharma, Lordship.
Delay of, my lord, 199 days, paragraph 4 of their petition.
Yes, the files have traveled from here and there. Legal advice.
But my lord, it is not mentioned, my lord. When my lord obtained the, my lord, not mentioned when approved. When legal opinion, my lord, saying, my lord. They, my lord, after DD, they sent to Kolkata office, my lord. From where? Kolkata office, my lord, approved. Paragraph 4.
Have it next week.
Well,
What's it next week?
yes, yes.
Yes. Mr. B. Sharma, Lanet CGC, is said to be on legs on a different court. On a prayer made on his behalf, matter stands adjourned to state again on 17/6. Oh, sorry, Miss.
That's Miss.
My name is not so.
Just need to reflect the name of Mr. S. Chauhan, is the counsel for responding, the respondent in the cost list. Yeah.
May I please, your lordships, my lord? My lord, in the connected appeal, my lord, there is a 36 days of delay, my lord. And we have tried to explain it in paragraph 8, page 9, my lord.
Notice.
My lord, private respondent is there, my lord, that's fine.
Art Mr. A.R. with us, assisted by Miss. That's last one. For the applicant. So is that. But it's a. Potential of the big delay. By the director to be. You notice by 3 weeks. It's in budget,
Lordship actually appear for 3, 4, and 5, Lordship.
except for this will be a response, 3, 4.
1 and 2, Lordship. R. Borpujari.
Lord, one by the revenue, my lord.
Yes, Lordship, 1 and 2, Lordship, R. Borpujari's name may kindly be recorded. I think he is on lakes, Lord.
Star board, which are London. State council exemption. Spot on what and extra copies of the application be furnished to the other councils that we make within 2 weeks. Fine. Looking to take steps for service of notice upon the municipal number 6. Must be in 3 weeks. Just again for 3 weeks. My actions even will be back.
Deeply obliged.
Obliged, deeply.
May it please, my lord. I seek your lordship's permission to address through VC.
Yes, yes.
My lord, this are 2 writ appeals, my lord, item 38 and 39. assailing, my lords, the judgment of the single judge of 1st April 2026, my lords, to a limited extent, my lords, where a direction has been given by the learned single judge, debarring, my lords, the writ petitioners from raising, my lords, a plea of parallel proceedings in future. So our writ appeal is limited, my lords, to that finding at paragraph 139(12), my lords, that your lordships will find, my lords, at page 219.
At this stage, I think we'll have to look into the delay consideration.
Yes, the delay is 24 days, my lords. In fact, the single judge, my lords, directed the department, my lords, gave them liberty to initiate de novo departmental proceedings and to review the suspension orders within 45 days, my lords. So those after the review was done, my lords, on 5th of May, my lords, followed by the fresh so-called notice of 8th May, my lords, we have challenged this order, my lords.
Yes, any on appeal for the opposite party?
No, I am appealing for the state court.
Yes. What about the delay?
As regard the delay of 25 days, I have no.
You have no objection. Is there any private respondent?
No, my lords, all state.
All are states.
Okay, heard, Mr. A. Chaudhary, learned senior counsel. To RDC. And he is assisted by Miss Mbor for the applicant.
And Abhishek Roy, my lords.
You want to light up all your.
he is assisting me from Delhi, my lords.
And Mr.
Abhishek Roy.
Abhishek Roy, A. Roy, yeah. Also to RBC. By filing this application, it seeks consideration of 24 days in filing the connected appeal. It's the judgment in order taken 1/4/2026. Passed in WPC number 5862 of 2024. Of referring to the application. Lawrence Senior Counsel. Delay was occasioned.
Paragraph 3, my lords. In fact, the court had given 45 days time, my lords, to the department to review the suspension orders and then issue a fresh suspension order if it intends to carry on with the suspension. And also liberty to initiate de novo departmental proceedings, my lords. And all this happened, my lords, on 8th of May.
The liberty granted by the court to the authorities concerned to review the suspension order.
Within 45 days.
And the part where it was within 45 days. So was it reviewed?
Yes, my lords. This was reviewed, my lords. This suspension order was reviewed on 6th May. That your lordships will find, my lords.
All right, the suspension order after was reviewed on 6th May 2026.
And fresh departmental proceedings was initiated on 8th May.
Then why this appeal? Why have you filed this appeal?
My lords, appeal is restricted, my lords. If your lordships come to paragraph 219, my lords.
Restricted
to the finding rendered at paragraph page 219, my lords, paragraph 139(12).
The appeal is not before us.
Oh, I'm so sorry, my lord. In fact, my lords, if I can just, we succeeded before the single judge, my lords, on the point of non-compliance of sections 8B and 8C of the Commissions of Inquiry Act. So, my lords, single judge, my lords, held that the report cannot be used against the petitioners, my lords, as it has violated 8B and 8C, the safeguards given under 8B and 8C. But while doing,
you are
while
against.
I am against, my lords,
paragraph 12.
Yes, my lord, 139(12) at page 219, my lord, running page.
Your grievances is regarding the observation in paragraph 12.
Yes, my lord. Paragraph 139(12) at page 219.
And therefore, since the same was awaited, there is delay in filing the step. It's the connected appeal. Stop the learned senior counsel submits that the applicant is mainly agreed with the observation made by the learned single judge, that woman. Well, paragraph number 139, bracket, small Roman 12 of the of the judgment and order from the judge. He therefore submits that the delay in filing the extent, the delay in filing the appeals may be condoned. Yes. And
Lordship, may kindly say I'm seriously not objecting, Madam. Lordship, may I leave it to your Lordship? Lordship may pass the order. I'm not seriously objecting the delay.
Mr. Deena,
Lordship,
you appear as
senior governor of the court.
learned senior government advocate appearing for the respondents.
Lordship,
Submits that he has no objection.
I'm not seriously objecting. I leave it to your Lordship.
Okay, submits that considering the explanations tendered by the applicant, court may consider the same and pass appropriate order. Next paragraph. Upon hearing the learned counsels for the parties and on perusal of statements made in the application, we find that we find the explanation standard to be sufficient for condonation of the delay. Accordingly, the delay of 24 days of filing a connected appeal stands condoned. Highest as disposal. Then.
Your Lordship.
The registry shall now register the connected with appeal and post the same for admission.
May request for a short date, my lords.
Give it. We'll have it after the vacation.
Before, my lords, because my lords, now the fresh departmental proceedings have been initiated, my lords, and we have this ground available to us. My lords, otherwise, my lords, the proceedings will continue. There's a fresh suspension order which we need to challenge, my lords. That's the trigger for filing the appeal. And court said, my
18-6.
I'm very grateful.
39.
39 is also the same, my lords. 38 and 39. Same delay, my lord. 24 days delay.
So similar order can be passed.
Similar.
Yes.
Except for the case numbers.
Yes, my lords.
Judgment and order dated 1/4/26. As in WPC number 6191 of 2020. Delays 24 days. Yeah, same. 139. Paragraph 139 in Roman 12.
Same, my lords. My lords, instead of 18, may I request for 17, my lords, if it's convenient to your lordships.
Look, 18th, let it be on 18th, my lord. I am led by senior counsel Mr. Yan Kohli. He is out of station on 18th, my lord. Another matter is fixed on 18th, my lord.
Okay, very well. Very well. Very grateful, my lords.
August.
44 and 45 of the supply list.
May I please, your lordship? Lordship, this is a statutory appeal, lordship.
Lordship, this is statutory appeal, Lordship, against order of acquittal, Lordship, and filed by the appellant number 5 of item 45.
This is item number
44.
Yes, conviction.
Lot
44 is
against order of acquittal, Lordship.
acquittal. And
Lordship. And item 45 against conviction, Lordship.
This matter came last week, my lord.
And
But there was a condonation that has been delayed. Then today it has been fixed because this item number 44 is yet to be admitted.
Lordship. Lordship.
Yes, my lord.
LCR received, Lordship. LCR already received.
your name?
Ayu Chaudhary, Lordship.
Mr. Ayub Chaudhary, and a consolidation of criminal appeal number 213 of 2026. And criminal appeal number 240. No, you are for? You are for the appellant in item 40.
Both, Lordship, both.
In both.
Both.
And criminal appeal in both the appeals. First of Mr. Kosif, learned APP appears for the state. It is stated that the criminal appeal number 213 of 2026 has already been admitted. And the paper books are ready. Full stop. Criminal appeal number 240 of 2024.
213 yet to be admitted.
213-26.
213-26 yet to be admitted.
It is submitted that the criminal appeal number 240 of 2024 has already been admitted.
And ready for hearing, Lordship.
And is ready for hearing. Paper books have been supplied to the learned counsels. Stop. Criminal appeal number 213 of 2026 arises out of the same judgment.
No, Lordship,
Where
same
the-
occurrence, Lordship.
Same occurrence where?
Cross affair. Two affairs,
Of the
Lordship.
same occurrence where the acquittal order has been assailed. Stop. Admit the appeal. Since paper books are already prepared in the other one, we need to call for the TCR.
Already arrived, Lordship, TCR.
Since paper book is ready, release this this packet, this appeals in the hearing form.
Lordship.
Come up for hearing now.
Lordship. In the meantime, Lordship, we will file our compilations, Lordship. Item 45 paper book prepared, but order of paper book is not there, Lordship. In item 44, Lordship. So we will, Lordship, prepare the compilation, Lordship.
Is everybody to file their compliance?
separate paper book is required. Separate paper book is required, otherwise.
Lordship, because Lordship, PS case number is different, Lordship. In item 44, Lordship, PS case number, Kolaigaon PS case number 44 of 2017.
Okay, you
And
final compilation.
Lordship,
We'll see.
Lordship. Deeply obliged, Lordship. Lordship, we fixed a date for hearing, Lordship.
In terms of due course.
After vacation, any day. Deeply obliged. Deeply obliged.
For admission, item 9.
My lord, I challenge the judgment or order the 7/3 of 24, my lord, which is also will find page number 61, my lord. In this case, my lord, advertisement was issued on 20 June 2015 for the post of Kriyasari and Samhita for the post of lecturer in the Ayurvedic college, my lord. I have applied for two posts, Kriyasari and Samhita Sanskrit and Siddhant, my lord. Accordingly, I have appeared in Viva Voce, which was held on 23rd of December 2015. Their result were declared on 8/9/2017. I have challenged the result of private respondents number 3 and 4, my lord, by which they were selected for the said post. On the ground that, my lord, the private respondents, more particular respondents number 3, he was awarded marks on the basis of experience and additional qualification. Without any basis, my lord, he does not have any additional qualification and does not have any experience, though he was awarded marks, my lord. At the time, my lord, the chairperson was the R.C. Pal, and one of the board member was Samidur Rahman, my lord, APSC. The selection was made by the APSC, my lord. Samidur Rahman was one of the member of the board, my lord, at that time, for the Kriyasari, my lord. And respondent 3 was selected for the third post, though he does not have any additional qualification and experience. Thereafter, learned respondents were directed to produce the record, but on the basis of record, my lord, entire record was not produced. Only partial record was produced for the marks, my lord. No, entire record were produced. Not, my lord. That record was on the prepared on the basis of 2017, my lord. Viva was held on 23rd of December 2015. That original record of Viva was never produced, my lord, for granting of marks, my lord, on the basis of which the tabulation of marks was prepared. Now, lordship kindly come to the page number 61 judgment, my lord, and relevant point, my lord. Page number 68. I have categorically made allegation against the respondents number 3, my lord. And kindly paragraph 15 of page number 16, 8, my lord. Kindly see, my lord. Coming to the second part of the argument, award of marks, etc. This court perused the records produced by the learned counsel. After perusing the same, this court is unable to hold that selection committee either has granted more marks to the respondents number 4. I have categorically make an allegation against the respondents number 3, my lord. But so far as respondent number 3 is, there is no any findings, my lord. Without any findings, so far as respondent number 3, my lord, this judgment was passed, my lord. And without producing the original marks of Viva Voce, my lord, that was held on 23rd of December 2015, my lord. That was vital, my lord.
So you should have filed a review.
My lord, no,
Appeal?
no, my lord. I file appeal, my lord. At least lawsuit direct the respondents, particular finance, the health department, to produce the Viva Voce records, which was held on 23rd of December 2015, my lord. That was vital, my lord.
You have made an allegation against the respondent number 3.
3, my lord.
To what extent?
He does not have any experience. He does not have any publication. Though does not have any experience and publication, he was awarded marks, my lord. I categorically pleaded in a writ petition, and that was not denied by the respondent number 3, my lord.
Who appears for respondent number 3? Yes.
Number 3.
He says you don't have publications.
Pardon me, your lordship. Your lordship. No, your lordship, if you go through the advertisement. May I please, your lordship? If we go through the advertisement, your lordships, then there is no such criteria given. We have not denied that we do not have. In fact, in the court itself, we have said we do have at the time, your lordship, in the petition. Yes, your lordship, it is in the record, your lordship. Furthermore, yes, there also.
There is no denial, my lord. No denial.
I have no I have not even accepted the fact, your lordship.
So if the advertisement does not require
And he has compelled
experience
mental.
or any documents to be given, on what basis you are saying?
My lord, then how he scored the mark on that?
Oh, that is for the selection to be,
That's why, my lord,
selection to be said to like that.
my lord, that's why when original record of Viva verse is required, my lord, only call for the original record of Viva verse. That was held on to.
Say he got 2 marks, 3 marks. We just say I asked him this question, he answered it this one, and therefore I was.
That was my lord. That is a vital, my lord. 2 marks, 3 marks is vital, my lord, for that post, my lord.
Lordship, can I bring a vital fact before?
No interest.
Yes, sir.
Election of 2015.
Yes, your lordship.
17. 17. madam.
Election date is of 17, your lordship.
Election was 17.
Yes, 8th.
17. There was no stay over.
No.
There was 13.
Subject to outcome of the repetition, my lord. There is order subject to outcome of the repetition.
Petition outcome is there.
Yes, sir. Chauhan, JP Chauhan.
JP Chauhan and counsel for the appellant. That's for the respondent of B.
3, your lordship.
JP.
Maybe it's by a date.
The standing counsel for the APC shall keep the records available on the next report, as and when the case is hosted.
Original record will be sent with the final department. Health department.
Original record after selection and the health department, and the other the marking and interview got certificate copy is looking that.
Certified copies.
That's it.
Would keep the certified copies of the records of the interview available with the APSC.
On 23rd, 12, 2015, my lord, kindly Viva Voice record 23rd December 2015.
Along with the records of the Viva was held on 23rd of December
2015.
2000.
Eleven, 12, and 13.
This matter relating to the petitioner has challenged the appointment of the respondent number 5. to the post of head assistant by promotion on the ground that he was junior to the petitioner, my lord. And moreover, he has no requisite qualification. By condoning age of 5 years in the exercising, so-called exercising the rule 17 of the district and chief judicial minister establishment, his 5 years age was condoned from 10 years and he was appointed. Their appointment we have challenged before the learned single judge. Learned single judge rejected the petition on the ground that my post was not entered in the Assam district chief judicial minister service establishment because the chief post of accountant has been sanctioned in the post of 2007 after creation of 3 new districts, Udalguri, Baksha and Sirangi district. 3 post of accountants were created. And according to my petitioner, at that time he was at Udalguri, he was senior most LD assistant. So accountant post is equivalent to the UD. So he was promoted to that post in 2012, my lord. 2012, but the government has not encountered it in the district and chief judicial minister establishment medical services. On that ground, the learned single judge has rejected the PI and directing the government, the High Court, to encounter that post in the judicial chief judicial minister establishment rule by amending rule. To that effect, since October, the instruction has been received from the respondent authority, what are the government has taken a step to amend the rule for encountering the post of the accountant to the head extended on, but that instruction is not received, my lord. But my petitioner only, he has hardly 1 and 6 months service in his credit, my lord. He was illegally deprived of his promotion, my lord. So on merit also, my petitioner, there is a court, though it was not engathered, it has been equivalent, that post of head assistant is equivalent to the AUD. Learned single judge has called for instruction from the High Court also. High Court has given it, these are on record, my lord. The High Court has given instruction that the head assistant and accountant are same cadre and same the feeder post for promotion to the head assistant, my lord. The government has also filed affidavit within government notifications that the head assistant and accountants are the same post. So in the to be head accountant and assistant are same post. To be head assistant, one has to complete 10 years of service as UD assistant. The word accountant is not there, but as accountant, he has completed more than 10 years of service. So he is completely eligible for promotion to that post. But it is not encountered, he was not given, my lord. But the respondent number 5, who was promoted, he has not completed 10 years of service, but his 5 years service has been condoned by the learned CGM by exercising power rule 17. But the CGM cannot do, CGM cannot do without the approval of the High Court because under Article 235 of the Constitution, High Court has control not only about the subordinate judiciary, not the judicial officer, but also staff of the subordinate judiciary. So it is a major decision without the approval of the High Court, the age cannot be condoned.
Okay. You are there in all the appeals. You are the appellant in all the 3 appeals.
Item 11, my lord. I mean item 12.
Mr. Sharma is 11. Any instructions?
Lordship, my senior, Mr. H.K. Das is on legs in another court. He's on the way, Lordship. After some time, it will be taken up.
We have next week.
Next week before vacation may fix, my lord.
That's what next week.
Before vacations.
But the regular bench is dealing with this matter. I've seen a lot of notes here.
Petitioner has
So
only
probably it will be better.
has only 1.5 years of service, my lord, in his credit, my lord. He was for last 2 years by illegally depriving him. Respondent number 5 has entering the post of the head assistant, my lord. He is junior to him and he is not eligible, my lord. So before vacation, it may take. Next week. Next week. Next week we will give it.
Hearing date. Okay, parties are represented by the respective councils. This might.
Next week. Obliged.
In this case, I'm appearing on behalf of the fishery department. For the first time, I lost the brief lot. I missed the brief, so I need something. Copy.
Misplaced the brief.
Mistake.
And you're appearing for the first time also.
The first time, so it was a earlier time I was not there. So,
Any urgency in the matter?
Yes, there's urgency, my lord. So date will be fixed. Then the council is already there. No, I'll.
Fisheries.
My lords. Because I am the highest valid bidder, my lord. Our settlement was the lowest bidder, my lord.
You had withdrawn from the.
Yes, my lord. That is the question, my lord. I am withdrawn. One time I withdrawn. That communication was communicated to the respondent authority. Subsequently, I submit other revisions. I will contest it, my lord. Both the communication, there not any response, my lord. That's silent. Whether it don't or it.
He does not have a copy of the.
Yes, so I am admitted. So I do not need opposition that clear, my lord.
The term of that. Fishery. Term of the fishery.
7 years, my lord. In July, my lord, any date, my lord.
in July, any day,
Date I am after.
after vacation, any day.
All right, after vacation.
Yes, my lord. Date may be fixed, my lord. Otherwise,
The request made as specified by the parties in this. 21 step.
hello, pleasure.
Item 19.
That 21, but hearing date may be most only, my lord. 21 is the hearing day, my lord. 22,
It'll be better on that hearing date. So the matter can be heard also, admission hearing.
yes, all lordship.
19.
Yes,
Chief, in the matter, my senior, Mr. H. Gupta, is in legs in another court. If the matter may be adjourned for the time being.
who's for the other side? Notice not yet gone.
Sorry, Rajiv.
Yes, appeal, with appeal. Delivers Manor, I think. With that. Have it next week.
Sorry, Rajiv.
Have it next week. Mr. H. Gupta.
May be taken up after some time.
How many cases are there left? Okay, take it. Maybe. By the time the other matter finishes, if it doesn't reach, then we'll have to.
May I please start? As per order, they file additional affidavit, so we will file our reply. Additional affidavit not in the record.
It was filed today also.
Counsel for the appellant submit that he has filed the affidavit today. But it is seen that the same is not yet connected to the report. Stop at the same time, the learned counsel for the respondent, Mr.
Eldeka.
Eldeka, submits that you would like to file a response to the same. You have a problem. When? List on 22/7. The registry to verify and connect the affidavit filed relate to the report. Liberty to the respondent to file to affidavit of position.
Item 21.
It appears it is CBI versus NI.
I had an impression both of you would be on the same side.
What is the bond potential?
This is a matter wherein the accused person is languishing in the jail from last 11 years. Of course, there is certain problem because he was arrested on 27/6/2011 for the first time and was got bail, released on bail on 16/6/2012. Thereafter, he appeared regularly and the charge has also been framed. What happened, Your Lordship, from 14/10/2014, he could not able to appear because he has surrendered and certain threatening is coming up. So he could not able to appear because there was certain negotiation is going from with regard to this government of India after surrendering or coming to some certain negotiation with the government of India. So, and he is also getting, because he has surrendered, he is also getting a threatening from the other underground, their colleagues. So he could not able to appear regularly. So warrant of arrest has been issued and thereafter he has again arrested on 27/11/15. There is no intentional latches on his part or default. There is circumstances prevailing over there because he has surrendered and the other underground his colleague were started threatening to avoid that, and he has also applied before the government to give the security. That also he did not get. So because of this period from 14 to 15, 14/10/2014 to 27/11/15, he did not appear and thereafter he was arrested on 27/11/15. My concern is that he was there in the jail total period more than 11 years. And the maximum period in section 38 is 10 years and for section 20 is of life imprisonment. So I am before your lordship, if any terms and condition, if your lordship will allow me to remain on bail, if possible, I will remain in this jurisdiction, Gauhati itself also. But I am still there and my trial is still under uncertain position. There were all total in more than 217 witnesses and as of now 123 has been examined from 27/6/11. So this is the situation in my case, and to that effect lordship is well aware of the cases, Najib's case, and thereafter one new case has recently 2026. This is in respect of Syed Iftikhar Andravi and National Investigating Agency. This is a very new case which has relied earlier case also, Najib's case also it has been relied. So there is nothing to argue on this case. This is the problem with this accused because in the meantime he defaulted, admittedly. It's a matter of record also. But there is not intentional. So if I permitted to remain on bail on any terms and condition, I'm ready to give attendance to the concerned.
Have you announced the earlier bail order?
Lots of earlier bail order, yes.
Yes.
Earlier bail order. I've got it. Page,
Is it page 53?
Come to page 39.
page,
59, I'm sorry.
page 48. First bail granted. You shouldn't go there.
Page?
49, 16, 6, 12, page 49.
E9.
No, this was rejected on 48.
This is by the NI court only. Correct. 16/6/2012.
Page, that's
48. You said page 48.
16/6/2012.
Page 48.
Page 48. Yeah, rejected.
This was the bail granted to you.
It was the first application.
Thereafter,
And thereafter, we have come to the High Court, your lordship, that is at 53, page 53. And we are directed to go to the court below. In terms of the above, the bail application be now again placed before the learned special judge court Mia for doing the needful as indicated above. It is at page 53 to 58, your lordship. And page 59 is thereafter we have appeared there in the special court. Impugn order is.
madam. Let us go meticulously, okay? 16/6 is the bail granted to you. Correct?
Yes, sir. Yes, sir.
Thereafter, you did not appear.
Yes, sir.
So your bail was cancelled?
We appeared up to 14/10/2000.
You appeared few days thereafter, you can disconnect,
Yes,
you disappeared. Then thereafter, the bail was rejected.
Yes, yes.
You were taken to custody.
On 27/11/15,
Ah,
rearrested.
rearrested.
Yes.
27/11.
27/11/15, rearrested. I defaulted for 13 months.
Bail rejected. Then you came to this court
Yes, sir.
by filing criminal appeal 1.
Yes, sir.
I'm sorry, criminal appeal 329.
329.
329.
329. The order dated 22/7/19. At page number 54.
Matter was sent back.
Yes, yes. Sent back.
On what ground?
It is.
What reasoning?
That is on the ground of 43D5. It is at paragraph number 14, your lordship, at page 58. It is further provided that in passing the order, no view has been expressed on the merit of the claim of the accused appellant for bail, and no provisions of this order shall be construed as such. It is explicitly made clear that the order is passed merely for complying with the requirements of proviso of section 43D5 of the UAPA Act 1967. 31 3 को भी तो दीजिए।
Yes, what is 43D5?
Yes, you can. I am coming. इसमें तो हमारा 43
Come to page 55.
43D.
It's that secretary. Come to page 55.
Shall I go through your
Page 55, we just read notwithstanding.
Page 55.
It's abstracted in the order itself.
Yes, yes. 55. We have perused the order dated 6/10/16. In the order dated 6/10/16, the bail application of the applicant had been rejected, amongst other by providing as follows. He further stated that the conduct of the accused in this case has been such that that if released on bail, he is most likely to jump the bail, again resulting in unnecessary delay of trial. The learned PP further attracted my attention to the proviso of section 43D5 of UAPA Act, wherein it has been provided that bail shall not be granted to an accused if there appears a reasonable ground to believe that accusation under any of the offense falling under the chapter 4 and or chapter 6 of the UAPA Act is prima facie true. On perusal of the report submitted by the IO under section 173 CRPC, it appears under section 18, 20, 38(2), 18A, 39(2) of the UAPA Act, inter alia other section of the UAPA Act and the Indian Penal Code. The embargo of section 43D5 of the UAPA therefore appears to be applicable in respect of this accused. Shall I go through further?
Where are you reading?
This is at 55, page 55. And
Apparently or not.
not-
Our fees are not apparently maintained.
She is in paragraph 4.
Maybe
She is
53.
in paragraph 4 of the order passed by the High Court, Lordship. 22/7/2000.
Paragraph 4.
And your Lordship was perhaps referring to paragraph 6.
Paragraph 4 and thereafter paragraph
Yes.
643.
I was asking you to read that provision which is abstracted, paragraph 6. You started
6.
reading somewhere else.
Notwithstanding anything contained in code, no person accused of an offense punishable under chapter 4 and 6 of this act shall, if in the custody, be released on bail or in his own bond unless the public prosecutor has been given an opportunity of being heard on the application for such release, provided that such accused person shall not be released on bail or in his own bond if the court, on perusal of the case diary or the report made under section 173 of the code, is of the opinion that they are a reasonable ground for believing that the accusation against such person is prima facie true. Section 43D5 provides that notwithstanding anything contained in the Code of the Criminal Procedure, no person accused of an offense punishable under chapter 4 and 6 of the UP Act 1967 shall, if in custody, be released on bail or in his own bond unless public prosecutor has been given an opportunity of being heard on the application for such release. And section 43D5 begins with non-absentee clause to be interpreted that in spite of any other provision contained in the Code of the Criminal Procedure, a person accused of an offense punishable under chapter 4 and chapter 6 of the UAP Act be released on bail only upon giving an opportunity to the public prosecutor to be heard on the application for such release. Shall I go further?
So paragraph 11 is the opinion of the court.
Opinion, yes. In the circumstances, we are of the view that a mere conclusion that there is a prima facie material against the accused in the report of the investigating officer would be a little short of the requirement of the proviso to section 43D5, where the court is required to form an opinion that reasonable ground exists for believing the accusation against the accused as true. In view of the above, we send back the matter to the learned special judge's court, Assam, NIA Assam for passing a further order upon perusal of the report submitted by the investigating officer as to whether on perusal of the report, the court is of the opinion that there are reasonable ground to believe that the accusation against the accused appellant is prima facie true. However, as the matter has been remanded back not for a fresh consideration, but for passing appropriate order as required under the proviso to section 43D5, we do not interfere with the order of the NIA court in any other manner, including its formation of the view whereby the bail is stood rejected. The NIA court, upon doing the needful is indicated above, shall pass any order as it deems appropriate under the fact and circumstances as well as law prevailing in the instant case. It is further provided that in passing the order, no view has been expressed on the merit of the claim of the accused appellant for bail, and no provisions of this order shall be construed as such. It is explicitly made clear that the order is passed merely for complying with the requirements of the proviso to section 43D5 of the UAP Act 1967. In terms of the above, the bail application be now again placed before the learned special judges court, NIA, for doing the needful as indicated. The appeal is stand considered and concluded as indicated above.
Then thereafter,
And the next page is the order of the court below, that is on 31/3/2020.
yes.
And coming to the observation part.
Hmm.
I think so. Para 31. Page 72, para 31.
Yes, read.
The case diary indicates seizure from the accused, among other things, JB Law College ID Bangladesh bus ticket, notepad containing diagrams showing explosion and abuse, mentioning of 1,700 pieces of Rambo knife, 900 pieces of hook, 700 pieces of sleeping bag, etc. The material in the case diary indicate lot of activities pertaining to extortion in the name of KCP MC, proposed extortion, calculation of extortion amounts, threatening of the person for the purpose of extortion, etc. The diary indicates travels of the accused to Bangladesh. The statement of the brother of the accused pertain to running away of the accused from home while in class 10 to supposedly join the underground. The statement of the editors and other person of the newspaper revealed that press notes were sent to them for publication regarding the terrorist activities of the KCP MC, and they were also threatened in case of non-compliance. In this regard, I have perused the translated version of some of the press released, para 32. The case diary also revealed that several police cases were registered in Manipur against the accused Sri Gopendra Singh A1 over various incidents, including those of bomb blast, and the statement of several of those investigating officers have been recorded, wherein they have implicated him. The case diary also revealed materials regarding alleged killing of innocent people by the cadre of KCP MC at the behest of the accused. I have also perused the statement of his landlord in Gauhati and Silchar. The statement of one of the co-accused is the effect that KCP MC is one of the faction of the band KCP. Para 33. I have also perused the detailed statement of the accused himself, in which they admitted to arms training in Bangladesh organizational structure of KCP MC, extortion of money, killing of government officials, etc. Of course, such a statement before the police would not be admissible in trial, but as laid down in Vatali Supra for the purpose of making a determination under the proviso to section 43D5 of the UPA Act, the court at that stage does not have to go into the admissibility of the otherwise of the statement or evidence. Para 34, I have perused the statement of some of the person stated to have been invited by the accused to sing song at the raising day function of the organization KCP MC. I have also perused the statement of witness identifying him, video footage. The statement of the wife of the accused indicates receipt of some money in her account, though she find ignorance regarding the same. One of the witnesses has stated before the investigating authority that he deposited a large sum of money in the account on the threatening of the accused. Para 34. After perusing the relevant portion of the case diary pertaining to the accused Sri K. Gopendra Singh A1, I am of the considered opinion that this material prima facie lends support to the findings of the charge sheet submitted against him regarding his membership of the prescribed organization KCPMC, waging war against the state, commission and or abatement of terrorist activities, organizing arms training for terrorist cadre, professing the ideology of the terrorism and violence, threatening people, extortion from official and civilians, bomb blast, killing and assassination, channelizing illegal fund for terrorist activities, etc. Para 36. In terms of the concept of the proviso to section 43D5 of the UAP Act investigated in the Jayanta Kumar Ghosh Supra, if the material in the case diary and the charge sheet are assumed to be true, such material prima facie to make out a case against the accused Sri Gopendra Singh A1. Now going further in terms of the test devised by the Honorable High Court in the aforesaid judgment, upon perusal of the material in the case diary and the charge sheet, I do not find anything therein that makes the case against the said accused wholly improbable. Para 37. Thus, the aforesaid fact and circumstances upon perusal of the case diary and the charge sheet against the accused Sri Gopendra Singh A1, the court come to the inevitable opinion that there are reasonable ground for believing that the accusation against the said accused person is prima facie true. Consequently, in terms of the mandate of the said proviso to section 43D5 of the UAP Act, once such an opinion is reached, the special court is barred from granting bail to the accused, irrespective of the other aspect of the merit or otherwise of the bail petition of the accused. For this reason also, this court will not be able to go into the other aspect of prayer for bail submitted by the learned defense counsel, including the aspect of illness of the wife of the accused. Para 38. Apart from the aforesaid finding, it is also worth noting that charges have already been framed against the accused Sri Gopendra Singh A1 under section 18, 18A, 20, 38, 2, 39, 2 of the UPA Act as well apart from the other panel sections. 39. In this regard, the Honorable Apex Court has held in case of Vatavalli Supra that the standard of prima facie satisfaction for the purpose of bail under proviso to section 43D5 of the UAP Act is lesser than the standard of satisfaction with regard to the prima facie case for the purpose of framing charge. It has been further held in this context that once the charge are framed, the defense will have to undertake the arduous task of the convincing the court that despite the framing of charge material presented along with the charge sheet do not make out reasonable ground for believing that the accusation against the accused is prima facie true. The implication of such an interpretation is that once charges are framed, it means that the court has recorded a prima facie satisfaction regarding the veracity of the material against the accused at that stage. Para 40. Nevertheless, in the instant case, this court has recorded its opinions as required by the proviso to section 43D5 of the UPA Act only on the basis of the material in the case diary and the charge sheet against the accused. Para 41. Thus, in terms of the order dated 22/7/19, passed by the Honorable High Court in Criminal Appeal number 329/16, remanding back the bail petition to this special court for recording its opinion in terms of proviso to section 43D5 of the UAPA Act, this special court records its opinion as stated above, that in the fact and circumstances upon perusal of the case diary and charge sheet, the special court is of the opinion that there are reasonable ground for believing that the accusation against the accused Sri K. Gopendra Singh A1 is prima facie true. 42. As stated earlier, the Honorable High Court has not interfered with the earlier bail order. The special court rejected the bail, but had only remanded back the matter for recording of the opinion in terms of the aforesaid proviso. Nevertheless, considering the nature of the opinion recorded by the special court under the proviso to section 43D5 of the UAPA Act, the special court is precluded from granting bail to the accused, and therefore, at the level of this court, the order of rejection of bail is also stands. Before concluding, it is important to mention herein that whatever has been stated and discussed in the order has been done so only for the purpose of adjudicating the bail petition of the accused Sri Gopendra Singh A1, and nothing should be taken to be expressive any opinion to the prejudice of the said accused on the merit of the main case undergoing trial. Accordingly, in the fact and circumstances and in view of the above discussion, the instant bail petition for the accused Sri Gopendra Singh A1 giving rise to the instant miscellaneous case Niyamis case number 10/16 arising out of special Nia case number 2/12 is stand dismissed and disposed of on the aforesaid terms, return back the case died. Thereafter, we have filed this bail application on 13/6/25 before the special judge. Vatali has been changed by, Vatali principle has been changed by K. Najir. And thereafter another judgment has come, your lordship, very recent.
How is it changed? Tell us.
Okay, judge. Huh? No, 43D. Page. हमारा वाला box. इनको copy दे दें. और एक चीज़. नीचे. ये है ना, ये coming to the analysis, that is at paragraph number from number 9. Paragraph number 9 at page 3, your notes. Shall I go through your notes?
Yes.
It must be emphasized at the outset that there is a vivid distinction between the parameter to be applied while considering a bail application vis-a-vis those applicable while deciding a petition for its cancellation. In Puran versus Rambilas, it was reiterated that at the time of deciding an application for bail, it would be necessary to record reason, albeit without evaluating the evidence on merit. In turn, Puran Supra cited Guru Charan Singh State Delhi Administration, wherein this court observed that the bail once granted by the trial court would be cancelled by the same court only in case of new circumstances, evidence failing which it would be necessary to approach the higher court exercising appellate jurisdiction. Para 10. In the state of Bihar versus Raj Vallabh Prasad, this court ruled that deference must be given to the discretion exercised by the superior court in the matter of bail, save for exceptional circumstances. The aforesaid decision hold as follows. Para 14. We may observe at the outset that we are conscious of the limitation which bind us while entertaining a plea against a grant of bail by the lower court. That too, which is a superior court like a high court. It is expected that once the discretion is exercised by high court on relevant consideration and bail is granted, this court would normally not interfere with such discretion unless it is found that the discretion itself is exercised on extraneous consideration and or the relevant factor which need to be taken into account while exercising such discretion are ignored or bypassed. There have to be a very cogent and overwhelming circumstances that are necessary to interfere with the discretion in granting the bail. This material consideration are also spelled out in the aforesaid judgment, which whether the accused would be readily available for his trial and whether he is likely to abuse the discretion granted in his favor by tampering with the evidence. Para 11, it is fact that High Court in the instance case has not determined the likelihood of the respondent being guilty or not, or whether rigors of the section 43D5 of the UAPA are alien to him. The High Court instead appears to have exercised its power to grant bail owing to the long period incarceration and like a unlikelihood of the trial being completed anytime in the near future. The reason assigned by the High Court are apparently traceable back to the Article 21 of our Constitution, of course, without addressing the statutory embargo created by Section 43D5 UAPA. Para 12, the High Court's view draws support from the batch of decision of this court, including in Sahin Welfare Association Supra, laying down that gross delay in disposal of such case would justify the invocation of Article 21 of the Constitution and consequential necessity to release the under trial on bail. It would be useful to quote the following observation from the cited case. Then, bearing in mind the nature of the crime and the need to protect the society and the nation, TADA has prescribed in section 28 a stringent provision for granting bail. Such a stringent provision can be justified looking to the nature of crime, as was held in the Kartar Singh cases 1994 and so, on the presumption that the trial of the accused will take place without undue delay. No one can justify gross delay in disposal of the case when under trial perforce remain in jail, giving a rise to possible situation that may justify invocation of Article 21. Para 13. Even in the case of special legislation like Terrorist and Disruptive Activities Prevention Act 1987 or Narcotic Drug and Psychotropic Substance Act 1985, NDPS, which do have somewhat rigorous condition for grant bail. This court in Paramjit Singh versus State, NCT of Delhi, Baba alias Shankar Raghuman Rahodia versus State of Maharashtra, and Umrania alias Umumiam State versus Gujarat enlarged the accused on bail when they had been in jail for an extended period of time with little possibility of early completion of trial. The constitutionality of harsh condition for bail in such a special enactment has thus been primarily justified on the touchstone of speedy trial to ensure the protection of innocent civilians. 14. We may also refer to the order enlarging similarly situated accused upon the UAPA passed by this court in Angela Harris Santu. That was also a case under section 10, 13, 17, 18, 18A, 18B, 20, 21, 38, 39, and 42 of the UAPA. This court, in its earnest effort to draw the balance between the seriousness of the charges with the period of custody suffered and the likely period within which the trial could be expected to be completed, to note of the 5 years incarceration and over 200 witnesses left to be examined, and thus granted bail to the accused, notwithstanding section 43D5 of the UAPA. Tatyaram Gorkhe versus State of Maharashtra, an accused under UAPA was enlarged for he had been in jail for 4 years and there were over 147 witnesses still examined. So this is the parameter it has been discussed here. Now I am coming to Lordship 17, this leaving 15 and 16, which is quite relevant. 17, as regard to the judgment of Nia versus Jagul Ahmad Shah, Vatavali Supra cited by learned SG, we find that it dealt with an entirely different factual matrix. In that case, the High Court had reappreciated the entire evidence on record to overturn the special court's conclusion of there being a prima facie case of conviction and concomitant rejection of bail. The High Court had practically conducted a mini trial and determined admissibility of certain evidences which exceed the limited scope of the bail petition. This is not only was beyond the statutory mandate of the prima facie assessment under section 43D5, but it was a premature and possibly would have prejudiced the trial itself. It was in these circumstances that this court intervened and cancelled the bail. Shall I go further, Your Lordship? 16? 18.
Yes, just go to the relevant portion.
It is clear to us that the presence of statutory restriction like section 43D5 of the UAPA per se does not ask the liability of the Constitutional Court to grant a bail on ground of violation of Part 3 of the Constitution. Indeed, both the restriction under the state as well as the powers exercisable under the constitutional jurisdiction can be well harmonized. Wherever the commencement of proceeding, court are expected to appreciate the legislative policy against grant of bail, but the rigors of such provision will melt down where there is no likelihood of trial being completed within a reasonable time and the period of incarceration already undergone has exceeded a substantial part of the prescribed sentence. Such an approach would be safeguard against the possibility of provision like section 43D5 of the UAPA being used as a sole metric for denial of bail or wholesale breach of the constitutional right to speedy trial. Adverting to the case at hand, we are all conscious of the fact that the charges leveled against the respondent are grave and serious threat to societal harmony. Had it been a case at the threshold, we would have outrightly turned down the respondent's prayer. However, keeping in mind the length of the period spent by him in custody and the unlikelihood of the trial being completed anything soon, the High Court appears to have been left with no other option except to grant bail. An attempt has been made to strike a balance between the appellant's right to lead evidence of its choice and establish the charges beyond any doubt, and simultaneously the respondent's right guaranteed under Part 3 of our Constitution have been well protected. Yet another reason which persuaded us to enlarge the respondent on bail is that Section 43D5 of the UAPA is comparatively less stringent than Section 37 of the NDPS. Unlike the NDPS, where the competent court need to be satisfied that the prima facie the accused is not guilty and that he is unlikely to commit another offense while on bail, there is no such precondition under UAPA. Instead, Section 43D5 of the UAPA merely provides another possible ground for the competent court to refuse bail. In addition to the well-settled consideration like gravity of the offense, possibility of tampering with evidence, influencing the witness, or chance of the accused evading the trial by abscondence, etc. Conclusion 21. In the light of the above discussion, we are not inclined to interfere with the impugn order. However, we feel that beside the condition to be imposed by trial court while releasing the respondent, it would serve the best interest of justice and the society at large to impose some additional condition that the respondent shall mark his presence every week on Monday at 10 a.m. at the local police station and inform in writing that he is not involved in any other new crime. The respondent shall also refrain from participating in any activities which might enlarge communal sentiment in case the respondent is found to have violated any of his bail condition or attempted to have tempered the evidence, influence, witness, or hamper the trial in any other way, then the special court shall be liberty to cancel his bail forthwith. The appeal is accordingly dismissed, subject to the above stated. So this is the.
So this judgment is basically on the what unlikelihood of trial being completed.
Yes, Your Lord. The length of detention, Your Lord.
Length of period spent by you.
Yes, Your Lord. Almost he has covered 10 years. He's
You are
11
charged
years
under what
crossing 11
section?
years.
You are charged under what section?
I am charged under section, Your Lordship, 120B, 121, 12A IPC, and under section 10, 13, 18, 20, 38 to 18A, 39 to.
Maximum sentence?
Maximum sentence in life imprisonment in
Under?
section 20. Your Lordship.
20.
20, and other for 10 years for other section. 20 दिखा दो. Medical cycle.
So because of your long time here spent in jail and also the trial not being completed in short time, you sought for this bail. But earlier you were released on bail.
Yes.
You were on bail. And the reason was that since there was some
13 months, I absconded.
absconded, correct.
13.
And the reason was that you had some
Threatening I am getting
Threatening.
from the other underground colleagues, because I have surrendered and there is a commitment by government to make certain negotiation that has been failed.
But while you jumped the bail, nothing was filed before the court.
Reason is that I was getting threatened. I was appearing regularly, even the charge has been framed, Your Lordship.
But for 13 months, you had not appeared.
Those are the matter of record, even I am admitting the same.
Now, what is the stage of the trial?
It is still under the evidence. Trial is going on.
Stage of evidence means how many witnesses are there? I mean,
There's
how
more
long?
than 200, 270.
I will just clarify.
And 123 are examined. So
I will just clarify my. In so far as the trial is concerned, Lordship, 123 witnesses have been fully examined.
Okay.
124th witness has been partially examined, and the next examination will be on 20th of this month. And that is the last witness that we are going to examine, because the list of witnesses have been pruned out. That is the last witness which is going on. And in all probability, it will be over on 20th. And after that, the 313 and the argument. So more or less the trial is over.
Depends if they want to leave evidence.
Huh?
Defense
The
evidence.
defense wants
That
to
is for her, I don't know. That is for her. And I will just correct some of the statements given by my learned friend. What is
finished.
yes, yes. Yes, finished. Yes.
Some of the, I have completed the statement. Our part is over. You can go, my part is over because these are the matter of record. I cannot.
Yes, yes. Now, my friend is basically relying upon the decision of K.A. Najib, where the other co-accused have already been released. And this particular gentleman was there. The trial against the others were already completed. In K.A. Najib, only the petitioner therein, it was going on. Now, in this case, what has happened was the petitioner did not get a bail on a bail petition being filed or something like that. It was a default bail because we failed to file our charge sheet on time. Therefore, the petitioner was let to go on bail. And thereafter, a non-bailable warrant was issued. In the meantime, like some records I could collect today, that is of course not in my objection. The petitioner again started indulging in the same activities, and he was arrested by the state police. He was in the custody of the state police in another UAP matter where the charge sheet has already been filed, and we got his custody from the state police now. Therefore, under such circumstances, whether your lordship will be inclined to grant him bail. It is not a case that he was getting threatening calls or something. It reveals from the matters in the case of the state police that he was again indulging in the same thing. He started his network there. And he was arrested by initially the Katigora police station, but later on the jurisdiction changed and it was changed to Kalang police station. And charge sheet has already been filed in that case also. And so far as the trial is concerned, so far as the prosecution is concerned, lordship, our evidence is more or less over, lordship. By the next date, 20th, hopefully it will be over if the examination is over. That we are not going to examine any further witnesses. The list of witnesses has been pulled out. It will be 124. And if the petitioner does not adduce any evidence, it goes to 313 and the arguments.
That additional evidence you said.
That
Yes.
yes, I have got it, lordship. I have flag marked it. I've got 2 copies, lordship. If your lordship can. So or your lordship may allow me to file a additional affidavit. I can. Lordship will find the relevant documents from page 116 to 155. Madam, I am aware today. So otherwise, I can bring some of these materials on record.
I think you should get this on record.
Lordship. Because this will be an additional ground for me. It was not with me before, lordship.
The other ground also sounds good, that the last witness has been examined and they're not examining any further witnesses.
Lordship, that is a statement from me. Lordship can record that.
That is a development.
Yes, lordship.
And on
So
that,
we are hoping, lordship, in 2 months' time, maybe it will be, trial will be over.
Lordship, this is going from last 6 months.
No, Lordship,
And
because
some of the dates, they are not appeared.
124 number witness has been partially examined. I'm making a statement.
I'll record his statement.
Yes.
We'll record his statement and let him
It is
bring this
fixed on
material. with him.
20th and
Maybe
22nd.
a time bound to complete, so that they cannot say that somebody has not appeared or it will go on lingering like the, on last 6 months, it is getting lingered. Let it some time bound framework has to be made.
See, the court also has to function with its own, like with a free mind. If we put an embargo that unless you do this, this will happen or that, it will not be
It's
proper.
my humble submission, because though it is admittedly in the last stage, as they have said, and 200.
So that's why whatever Mr. Chaudhary has submitted, we'll put that on record so that on the next day, if nothing happens, we can confront him. See, this is what was stated last time. All right.
Lordship may place it after the vacation. Meanwhile, maybe this will be over, this examination.
124 may also be over by then.
Yes, it's.
Witness number
it-
124.
It is fixed on 20th and 20.
You say 20th of June?
20th and 21st is a Sunday.
22nd.
22nd.
Like what was he doing in Katigora?
Lordship.
With all the threat to his life where he cannot come to the court, what was he doing in Katigora? He has a threat here in Gauhati, not at Katigora.
There he is arrested, you have not.
He was arrested for doing the same.
This is not on record. This is not on record, my lord. This
Person
particular,
FIR knows where he was arrested.
that
The
is also,
FIR says so.
but that is not on record.
He's not very recording this case.
Yes, yes, yes.
In some other
What's for the promotion? We are considering the fee.
Very.
We will pay here only in Gauhati.
No, that is at the time 15. It is now 26. That
Yes.
happened in 20.
That was the time when he was on bail, Lordship. That was the time when he was on
So
bail.
only for 13 months, your lordship.
Unfortunately, he was arrested in Katigora in 2015.
Okay, Harsh.
Indeed.
Madam, your good name?
M. Kumari, Manorama Kumari.
Art M. Kumari, learned counsel for the appellant, and Mr. R.K.D. Chaudhary, learned DSGI for the respondent,
NIA, Lordship.
NIA. Stop agree with the order dated 13/6/2025 passed by the learned special judge NIA Assam Gauhati in Miss bracket NIA case number 14 of 2025, arising out of special NIA case number 02 of 2012 bracket RC 03/20 11 / NIA -GUW close bracket, rejecting the bail prayer of the appellant. But the appellant has filed the instant appeal by invoking section 21 bracket 1 and bracket 4 of the National Investigation Agency Act 2008 bracket NIA Act. Up next, learned counsel for the appellant submits that the appellant was earlier released on bail by order dated 16/6/2012 in NIA Miss case number 12 of 2012. But as he could not continue to make his appearance in the court, the warrant of arrest was issued against him and he was again secured by the authorities. The bail application submitted by the appellant by NIA Miss case number 10 of 2016 was rejected and aggrieved. The appellant approached this court
through criminal appeal number 329 of 2016. The appeal was taken up for consideration and disposed of by judgment and order dated 22/7/2019. After the court came to a finding that in terms of section 43, capital D bracket 5 of the UA bracket B Act 1967, an opinion is required to be formed by the court. And since, according to this court, only a conclusion was made about there being a prima facie material against the accused appellant, matter was remanded for that specific ground only. The bail rejected by the learned court below was not interfered with. On remand, the learned court below by order dated 31/3/2020 formed an opinion and disposed of the NIM is case number 10 of 2016 by order dated 31/3/2020. The appellant again by Miss NIA case number 14 of 2025 sought for grant of bail but the same was rejected by order dated 13/6/2025. It is against the same rejection that the instead appeal is filed by the appellant before this court. Next, learned counsel for the appellant referring to the case of Union of India versus K.A. Najib, AIR online 2021 SC 30. No, you cancel that. AIR 2021 SC 712 submits that the apex court in a case of similar nature, considering the length of the periods spent by the accused person in custody and the unlikelihood of the case being completed anytime soon, directed release of the accused person. The learned counsel submits that the same squarely applies to the present case as well. Since the petitioner, the appellant has been lingering in custody for the last more than 10 years. And only about 123 prosecution witnesses have been examined. Out of the named 217 witnesses. She submits that it was solely on account of the appellant having to face a threat from his former colleagues,
Yes, former colleague.
from the former
Underground farm.
from the members of the underground group, that he could not make his appearance before the court concerned. She therefore submits that pending conclusion of the trial proceedings, appellant may be released on bail. Next para. Mr. R.K.D. Chaudhary, learned at the DSGI, on the other hand, submits that the number of prosecutions have been scaled down to 124 only.
Stop, he summons that 123 prosecution witnesses have been examined. And the prosecution number 124 is being examined. And the next date fixed for further examination is 26/20/26. And that the said witness would be the last witness. Stop, he summons that if the defense do not have any witness of their own, the next stage would be for examination of the accused under section 313. Stop, he further submits that while jumping bail, the appellant has also been involving himself in other similar activities and other similar unlawful activities, and for which he has received certain materials, which includes a charge sheet. Charge sheet?
Yes, Lordship, he has been given a charge sheet and he has been yeah. Charge sheet number is
It is, yeah, it's in the RC 03/2011.
charge sheet number 106 of 25, dated 25/10/25, at page 147.
Of this part.
Yes. 147, Lordship. Page 147. And here also UAP Act is involved, Lordship. If your Lordship will see serial number 2, charge sheet number 106 of 25.
Yes, and the charge sheet number is 106 of 2025, dated 25/10/2025.
Under section 120B, 121A, 384, I suppose, 17, 18A, and 18B of the UAP.
Which includes charges under section 120 brackets capital B slash 121 bracket capital A slash 384 IPC, and also under section 17/18 bracket capital A slash 18 bracket capital B of the UAP Act. Stop. He therefore submits that release of the appellant pending completion of the trial is not desirable. He also submits that he may be given some time to file an additional affidavit to bring this in. Considering the above, we grant the SGI some time to file an additional affidavit. Let the matter be listed again on 23/7/2026.
So maybe by that time it will be over. So.
Please update us by the.
Yes.
No, you have to be back. They're going to file it.
Lordship will retain this.
Saikia, what is this?
My lord, these petitioners before lordship are master workers, my lord. All were, my lord, appointed prior to 1/4/1933. Earlier, my lord, there is a
You
direction
are
of,
seeking HRA,
my lord,
house rent allowance.
though in this, my lord, the writ petition as well as the appeal, my lord, the prayer was like that, my lord, because, my lord, at that point of time, my lord, the Upendas was holding the field. Upendas was holding the field. But earlier, my lord, this honorable court directed the authority, my lord, to regularize their services in the year 2011. But because of, my lord, Upendas hurdle, my lord, their services were not regularized. Now, my lord, that hurdle is no more there. Now, law has, my lord, changed, my lord, the honorable apex court has held that, my lord, the persons appointed prior to 1/4/1993, their services should be regularized. So, my lord, in view of that decision of the honorable apex court, my lord, should we direct the authority to consider their cases, my
Where
lord?
is that decision?
My lord, that decision is, I gave the list, my lord. Will I say it? A task. Extra copy.
Is it on that SLP?
My lord.
30056.
4514 2025. SLP 4514.
Huh?
It will be. I have got one extra copy, my lord. I have given. Paragraph 79. SLP number 4514 2025. Paragraph 79, my lord. At page 65. Judgment of the synopsis second yes. Regulation that is at the synopsis. Position is starting.
What kind of relief was granted?
Ballot honorable apex court hold that ballot in view of the cabinet decision dated 22/7/2005. Those master roll workers appointed prior to 1/4/1993, their services is required to be regularized along with the consequential benefits, including area salary, and if they have retired in the meantime, my lord, they are required to be paid their pension also. Paragraph 79, my lord. Paragraph
Yes,
79.
opposite party, what you say?
My lord, I have to take instruction because this judgment is passed on 21st of May, my lord. Pursuant to this, my lord, government has not taken any decision as yet, my lord. So it may come up in the month of August. In the meantime, some decision will come, and then in the meantime, I'll file my affidavit also to that effect.
Paragraph 79.
My lord, the 105 of the that judgment, the paragraph, the appellant shall be at liberty to agitate their claims for pensionary benefits before the appropriate authority or forum in accordance with the law applicable. Yes. Pension and other benefits. My lord. My lord, now I think, my lord, some decision shall have to be taken by the government also pursuant to this judgment, because man, that, no. Implementation, that's right, man, that's right. So, what decision the government is taking pursuant to this judgment, my lord. So therefore, we'll bring it on record, my lord.
Just open.
The specific direction is
Regarding Kelson part also, my lord.
Difficult decision. Covered by that.
but it is regarding only the 30,000 the master.
Yes, so what do we tend to do?
My lord, it is regarding this 30,000 master workers who government had taken a decision in the year 2005 that who were working since 1993. So an exercise has to be taken up by the government now pursuant to this judgment. Now the apex court said those who are left out, for some clerical mistake or for some reason during that time, like those among those 30,000, they are to be treated as equals, my lord. So we have to, my lord, now formulate some policy. Therefore, my lord, now these things are under consideration. So some policy will be formulated obviously in the meantime.
Will give us some time.
My lord, what I'm.
They don't have much way out.
What
Only
I'm
some time.
submitting, my lord. Proceed, my lord, directive to consider our cases, my lord, in light of paragraph 79. My lord, if we are, my lord, appointed prior to 1/4/1993, then my lord will be entitled. That exercise they can make, my lord. Whether we are appointed prior to 1/4/1993, that exercise they can.
Let me take some instruction, my lord, and file my affidavit.
These persons are, my lord, they are similarly situated persons, they are getting the benefits since 2005. These persons are not getting. Some of them have retired. My lord, initially we approached the High Court, my lord. That judgment loss will file at page 29, my lord. Page 29. My lord. Five. My lord. 3 years prior to the filing.
Because it has to be in, with the finance department also, she have to be involved in this matter. We cannot take our own decision. I cannot give.
Everyone,
Man,
everyone will have to go in.
man.
Initial decision perhaps is not required because the implementation part.
Department, how did they get considered? They don't even know where to start. With what document to start? To ask you of what?
The date of joining part. Yes, ma'am.
The committee which is going to do it. I think the time now.
That is also before them, my lord. That is also before them, even in record, my lord, because my lord, when in pursuance to my lord Upendas's case.
One particular case. They cannot do it for a particular case in the Supreme Court, they do it for all. Like, then somebody else will come up with another case. He wants a one step. Extend the probability. Then we should. But the part will be covered by the.
Actually, my lord, one more case, one more
One of
case
the
I'm
case
handling.
already disposed of, my lord, directing the single judge, my lord, court number 18. Last week, my lord, it was directed to the authority, my lord, to examine whether he was appointed prior to 1/4/1993. If he was appointed prior to 1/4/1993, he will get the benefit.
My lord,
That was the
one
direction.
such case, my lord, some 1,000 people are involved, and their direction has been passed by this court to examine this, whether they are appointed prior to 1/1993. In that exercise, we have completed the exercise. Now they have come back and said, no exercise are taken up. But they could not, what the records are there with us, huge records. They could not produce anything regarding their engagement, not a single document. We have taken up this exercise. So there are certain things which we have to streamline.
Very happen when the other committee set up that hyper committee and they take up some work. How do we put it down? And in the policy, if all people should take it, we tomorrow is something.
Lordship make, suggest the government to make a committee,
Study petitions, the topic is. Sometimes we completely that conflict.
Because in these cases, my lord, what happened, my lord, pursuant to direction made in Upendas, government has given the minimum scale of pay to all those persons, my lord, appointed prior to 1/4/1993. That list is, everything is there with them, my lord. Even in the order given, giving the minimum scale of pay, they have mentioned the date of joining. Regular scale of pay.
All we have to source is also to be identified. My your attachment.
We give us some time.
We are bound by this judgment. Only thing is formulating.
Please write. I had Mr. I cycle and counsel for the appellate. Submits that the judgment and order dated 8/6/2017 passed by a division bench of this court in writ appeal number 45 of 2014, bracket State of Assam versus Sri Upendas and 836 others, those bracket has been interpreted with, has been set aside by the apex court by judgment dated 21/5/2026 in civil appeal numbers 4514 of 2025. Bracket as the lead case. Post bracket. So consequently, the order passed by the learned single judge dated 2012/2013 has been affirmed by the apex court. So under the circumstance, the learned counsel submits that the appellants will be entitled to be given their scale of pay as per their entitlement. No, that's not as per the, will be entitled to be given a scale of in terms of the judgment of the apex court. Stop to this submission, Miss, your good name?
P. Chakraborty.
Sorry?
P. Chakraborty.
P. Chakraborty, learned standing counsel.
Yes.
Which department is this?
This is water resource.
Water Resources Department submits that. Oh, she may be given some time.
the matter, since the not only the department, but the government will have to uh, formulate the process for comply with the apex court decision. And the same would involve uh, some process. And consume some time. So she submits that since the same is a direction from the apex court, the department will definitely have to comply with this thing, but she may be allowed some time to get back to the court. To inform the process being undertaken. So, next paragraph, in view of above, we accept the prayer of the learned standing council and adjourn the matter. The case shall now be listed. Wait.
Sometime in August, madam.
Any idea about the other matters? No.
No.
But the single, before the single judge, all the matters are fixed for 16 of this month.
This month.
Right.
But this will go in August. So August when? First week?
Yes.
If possible, madam, during July.
July, it will be
Last
in
week-
August,
last
madam,
week of
so
July,
that
last
we
week of
come up with some.
We'll have it first week of July, August.
August.
List again on 5th of August.
Obliged.
May I please, Lord? Lord, here the order passed by the learned single judge's challenge, my lord, wherein, my lord, the learned single judge has interfered with a contract clause, my lord. That clause is at page 82. My lord, it is a clause which is called vitiation clause. It deals with vitiation of contract. My lord, pursuant to this clause, Railways has recovered certain amount from the respondents. Now, my lord, the impugned judgment, my lord, by that judgment, my lord, the learned single judge has, my lord, in a way taken away the entire effect of the clause. My lord, what was held by the court is that, my lord, since this clause does not provide for any methodology of calculation, the entire amount which is calculated to be recovered from the contractor, my lord, is therefore liable to be set aside on the ground of violation of Article 14. Now, Lord, the question before Lord is whether in a case of a concluded contract, whereby the parties have agreed to the terms of the contract, whether subsequently, my lord, a clause can be set aside on the ground that it is violative of Article 14.
Which is that clause?
Yes. The clause is at page 81, 6.0. If I may read, my lord. The title is, my lord, vitiation of contract.
6.0,
my lord, at the bottom, page 81.
Yes.
The contract shall not be vitiated by any inadvertent error of any kind in the surveys, information, specification, drawing, or schedule of quantities. However, during the execution of the work, if variation in quantities against item of work become inevitable and such variation cause vitiation of the contract, the amount of vitiation will be deducted from the contractor's bill. Now, my lord, what is vitiation, my lord? I will take, my lord, just by way of a small example. My lord, this is a example, my lord, in case of a hypothetical situation. My lord, this is a tabulation of tenderers of work. My lord will see the first column is the item which a tenderer may quote, my lord, X, Y, Z. Quantity is there, my lord, rate is there. And then X, Y is in case, and A, B, C are the different contractors. Now, my lord, this is the tabulation on the basis of existing rates given in the tender. When the tender is floated, my lord, a quantity is mentioned in the tender, rates are quoted by the contractor, and my lord will see the respective values. And at the bottom, my lord, grand total is L1, L2. Whoever has quoted, my lord, lower will be treated as L1. Now, my lord, during the course of execution, the second table, in case of course of execution of the work, in a case, in a situation, my lord, where the quantity of item 1 is increased from 100 to 125, in that case, my lord, we'll see in column X with the same quoted rate, my lord, the grand total becomes, my lord, higher than the earlier L1, meaning thereby, my lord, the L1 has to remain L1 during the execution of the work. In respect of a particular item, my lord, in case he is, my lord, doing some extra work, in that case, my lord, the extra amount, this is called vitiation, my lord. And this, in present case also, my lord, since the contractor has increased the amount of work leading to, my lord, excess amount, therefore, my lord, we have recovered the amount from him. If I might take to, my lord, to the tabulation by which the vitiation was done, my lord, this is a page. Yes, my lord. Refund, my lord. My lord, in my humble submission, that clause would remain, my lord, although so far as methodology is concerned, those are governed by the railway board circulars from the. Yes, ma'am. Paragraph 6 point, page 153. My lord, page 154. My
This
lord.
variation goes in the, if it goes excess. How do you define this variation?
No,
either low or high.
The higher one, my lord. If
Why-
it goes higher, then, my lord, it goes beyond the rates which the contractor has quoted at that initial time of the tender, my lord.
It supplies higher,
Yes.
but why only higher? It could be lower also. Variation.
No, it cannot be lower because that is the minimum work which he has to perform.
I see.
So during the execution of the work, in case, my lord, he may have to perform higher due to certain additional requirement. In-
Since the price goes up, can you cover the price?
No, no, the price, no, the purpose is that, well, the rates which he has quoted, well, up to certain extent, variation is permissible under the contract. That is, 25% variation is permissible. If the railway, gets some extra work done from the contractor, to some extent, my lord, it is agreed that the parties will, my lord, rate, agree to do the work at the same rate which they had initially, my lord, quoted the rate. It is only in case the variation goes beyond, my lord, 25%. That, my lord, in that case, my lord, he will be entitled to price variation.
Now, where is that 25%?
Yes, my lord.
This clause 6.0 does not say anything about that.
My lord, it talks about vitiation, my lord, and it also deals with variation.
Correct, but where is
Yes,
that 25%?
yes, my lord, I'm coming to that. My lord, page 69.
By the way, anyone appeared in this case?
Yes, my lord, they appeared, my lord.
Who appeared?
M. Biswas, my lord.
M. Biswas.
Yes, my lord.
There was a delay application.
That was condoned, my lord.
Delay condonation.
Condoned, that is,
They appeared. They
Yes.
appeared in the delay condonation application.
in delay they have appeared, yes, my lord.
Now, as far as this appeal is concerned, have they been served a copy?
Copy has been served, my lord.
When? Copy served, some acknowledgement has to be there.
Name is also shown, my lord. Name is shown in the list.
This is item 19.
Yes.
A.K. Choppy and J. Singho and A. Ghoshal. They're the ones.
Yes, my lord. No, you are not about to make the. Yes, 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 my lord.
Let them come. We'll post it again.
Page 69 was the, my lord, the clause which deals with variations. You know, this clause clearly provides that, my lord, up to 25% variation the railways can do.
Where is that?
That is at paragraph 2.8, my lord.
Page?
Page 69. The quantities specified in the schedule of work enclosed herewith are approximate and meant to give tenderer an idea of quantum of works involved. The railway reserves the right to increase or decrease the quantities against various items and add or delete from the item up to 50% of the quantities and even more as per the actual requirement at site. The successful tenderer have to execute all items required for successful completion of the work at the quoted rates. The engineer on behalf of the railway is authorized to order in writing to enlarge, extend, diminish or reduce the work or to make any alterations in the design, character or position of the site, dimensions or in the method of the execution or in the combination and use of the material thereof. The contractor shall be bound to carry out the work at the agreed rates and shall not be entitled to claim any claim or compensation whatsoever. However, payment for the increased quantities beyond 25% shall be made at reduced rate as specified as under. So, my lord, up to 25% variation, since it is permissible, if the rates go above the original quoted rates, my lord, that is called vitiation. And therefore, my lord, the calculations, my lord, if I may, this is the statement we have prepared. So, this is also there in the part of the record, my lord. These are the different items, my lord, description of work. This is a statement showing item-wise vitiation amount as under. And there are various description of items, my lord, will see. Then in the column number 4, the quantity is shown as per the CA. Thereafter, my lord, quantity finally executed by the contractor. My lord, I am taking serial number 1, my lord, serial number 2, my lord, I will take, where there is a difference which is shown, my lord. Quantity executed is shown, my lord. Thereafter, the quantity finally executed, rates are given, my lord, and then the amount, and then in column, subsequent columns are other, the L2. L2's rates are given, my lord. So if my lord sees there is a difference in the amount of 27 lakhs, 57,037.76. So in the same way, my lord, the entire tabulation is there, my lord. Somewhere it is in positive also and others are in negative. And finally, this amount vitiation comes to 25 lakhs, 21,881.28 rupees. My lord. The total contract, my lord, was for 18, my lord, 18 crores, 74 lakhs, 69,000. And this is followed, my lord, throughout, even today and even in, my lord, all the railway contracts vitiation clause is followed. And my lord, if this interpretation is allowed, entire, there will be floodgates of cases. It's not that, this vitiation clause is there in this agreement. Even today it is there. And even in past, prior to this contract, these vitiation clauses were there in all the contracts. This principle has been followed by the railways and the amounts were deducted. So in my humble submission, since the clause is existing, and there is also a methodology which may not be there apparently in the contract, but the contract agreement clearly says, that all the railway board circulars will be followed, during the execution of the contract. And in the affidavit which we have filed, we have annexed those circulars, at page 173. At paragraph.
You have filed your affidavit in opposition.
Yes.
In the writ petition.
In the writ petition.
What was the stand taken by you?
At page 177. Paragraph 18, my lord. That with regard to the statements made in paragraph 16, the defendant begs to state that the railway, while accepting the offer, considers the overall bid value of the tenderers and not the rates of the individual items. Accordingly, the lowest eligible and technically suitable L1 is awarded the work. It is quite possible that for some of the items, the rate quoted by the L1 may be higher, though overall he is L1. So it is quite possible for some items in which L1 is not the lowest, there is a positive variation in quantities, and for other items in which L1 is the lowest, there is negative variation in the quantities. Then vitiation can set in and L1 may not remain L1. Therefore, to ensure L1 ever remains L1 and the vitiation amount has to be deducted from the contractor as per the clause 6 of the additional specification of contract. So, the chart which I have shown, Malod, there, Malod, must have seen, Malod, there are positive variations also and negative variations also. And ultimately, Malod, finally the amount is calculated after comparing both, Malod, both the variations.
You have it next week.
Malod.
This is the matter again. This is the matter on 18/6/2026.